Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. CPC case law. Here we are going to discuss Order 12 Rule 6 of the Code of Civil Procedure. The question is whether judgment can be given based on admissions. Of course, the answer is yes, as all of you know. The matter has come to the Supreme Court. It's not that easy to say yes. Justice J.B. Pardiwala and R. Mahadevan in the case of Rajiv Ghosh versus Satyanarayan Jaiswal. Rajiv Ghosh versus Satyanarayan Jaiswal. SLP number 8323 by 2025. On 7th April 2025, held that or clarified that or interpreted that Order 12 Rule 6 clearly says judgment can be given basing on admissions, de-horse pleadings, even though the pleadings do not mention the same, even though the written statement does not mention the same. If, please remember, there are admissions, the judgment can be given. Simple example I tell you, there is a dispute regarding certain partition of property between 2 or 3 brothers, right? But the document is written by the father, both of them, they have to admit that there is a document. Existence of the document is, yes, accepted, it is admitted. Basing on the admission, yes, judgment can be given. This is what is said by Honorable Supreme Court of India. నేను చెప్పినంత తేలిక కాదు, బట్ ఎనీవే చూద్దాం కేసు. రాజీవ్ ఘోష్ వర్సెస్ సత్యనారాయణ జైస్వాల్. యాక్చువల్గా సత్యనారాయణ జైస్వాల్ ఈజ్ ది tenant of a particular premises. ఆయనకన్నా ముందు వాళ్ళ ఫాదర్, his father Ranjan Ghosh, actually he has taken Satyanarayan Jaiswal is the original owner, and the premises were taken by Mr. Ranjan Ghosh, that is father of Rajiv Ghosh, and he is paying monthly rent of 1700 rupees. This Ranjan Ghosh, he died on 13/7/2016. చనిపోయారు. అది కొన్నాయన చనిపోయిన తర్వాత 5 years have elapsed. ఆ తర్వాత దిస్ మ్యాన్ gave a notice. ఎవరైనా రాజీవ్ ఘోష్ గారు, సత్యనారాయణ జైస్వాల్, yes, he has given a notice to this so-called Rajiv Ghosh to vacate the premises because your father died. Already so much of period is over. I want to carry on my own business like that. Other reasons petti vacate chairman, he has given a notice on 27/2018. Right. So, but it was acknowledged by him on 21/7/2018, but no reply. Right. Therefore, he has filed a case under Section 2G of West Bengal Premises Tenancy Act 1997. దాని మీద వేశాడు. And this Rajiv Ghosh has filed the written statement. ఇక్కడ జరిగింది. In the written statement, particularly in para 10 law, line number 9 law, he has admitted that his father took the place for rent or tenancy. దాంట్లో రాసింది, he admitted. కానీ తనకేదో అవసరం, తను ఉండాలి, తర్వాత అలాగే ప్లెయింటిఫ్కి అవసరం లేదని రొటీన్లో చెప్పేశాడు. బట్ బేసింగ్ ఆన్ ద అడ్మిషన్ గివెన్ బై ది రాజీవ్ ఘోష్, ది సత్యనారాయణ జైస్వాల్ ఇమీడియట్లీ ఆస్క్డ్ ఫర్ ద జడ్జ్మెంట్, రిక్వెస్టెడ్ ద కోర్ట్ ఫర్ ద జడ్జ్మెంట్, బికాస్ ఇన్ ద రిటర్న్ స్టేట్మెంట్ హీ అడ్మిటెడ్ ద ఫ్యాక్ట్స్. సో దేర్ ఫోర్ బేసింగ్ ఆన్ ద ఫ్యాక్ట్స్ ప్లీజ్ గివ్ ద జడ్జ్మెంట్ అని ఇచ్చారు. ఇచ్చిన తర్వాత yes, the trial court gave the judgment. Order 12 Rule 6. Now you have to remember what is Order 12 Rules. Order 12 is regard admissions. So admissions need not be proved. Basing on the admission, Rule 6 says, Rule 6 subclause 2, subrule 2 and all, says decree also can be taken. Judgment can be given under Rule 6 and decree also can be given Rule 6 subrule 2. So therefore, దీని మీద yes, trial court has given the judgment, vacate చేయమని ఇచ్చారు. దాని మీద దిస్ మ్యాన్ రాజీవ్ ఘోష్ హెస్ గాట్ టు ది హైకోర్ట్. హైకోర్ట్ డిఫర్డ్. సో కేవలం అడ్మిషన్ మీద కాదు, యూ హ్యావ్ టు కండక్ట్ ది ట్రయల్ మొత్తం చేయాలి. ఇది కరెక్ట్ కాదని చెప్పి హైకోర్టు తీసి నౌ ద మ్యాటర్ హ్యాస్ కమ్ టు ది సుప్రీం కోర్ట్. Supreme Court, basing on the precedent previously decided case law, that is Shivalinga versus Narayani 1946, లేకుంటే లేటెస్ట్ కేస్ Uttam Singh versus United Bank of India 2000. Another case law also have written ITDC Limited versus Chandrapal Sood and Sons 2000. They clearly stated that if there are admissions, basing on the admissions, definitely they can deliver the judgment. So the Honorable High Court has committed error regarding the trial. Not necessary. It is enough if there is admission. Basing on the admission, the court can deliver the judgment. So this is accepted by. So ultimately the appeal is dismissed. Supreme Court clearly stated that judgment can be given basing on the admissions as per Order 12 Rule 6. If you remember this much, it is sufficient. Thank you.